We are on the record in the 13th Judicial District, the District Court of Greenwood County, Kansas. This matter does come on for preliminary hearing in case number 2025 CR 24, State of Kansas versus Lisa Ann Prim. Please announce appearances.
You're muted, Ms. Gillette.
May it please the court, the state appears by Judge Gillette, County Attorney.
Ms. Prim appears with counsel Joseph Favre. She's at the Greenwood County Jail.
Is counsel ready to proceed with preliminary hearing?
Judge, we do have an announcement. I've spoken to Ms. Gillette. We're very close to reaching a plea agreement. I've spoken to Ms. Prim. And at this time, we're going to waive our right to an evidentiary hearing and then ask this be set for arraignment, please.
Very well. Ms. Prim, you are charged in count 1 with possession of drug paraphernalia with the intent to manufacture, distribute. This is a level 5 drug felony. You're charged in count 2 with distribution of a controlled substance. This is a level 4 drug felony. You are charged in count 3 with possession of the, let me make sure I got that right. Count 1 is possession of drug paraphernalia, knowing it will be used to manufacture or distribute a controlled substance, a level 5 drug felony. Count 2 is unlawful distribution of a controlled substance, to wit, methamphetamine in an amount of at least 3.5 grams, but less than 100 grams, a level 4 drug felony. Count 3, unlawful possession of the controlled substance, methamphetamine or MDMA, a level 5 drug felony. In count 4, failure to pay or failure to possess a drug dealer tax stamp on a certain quantity of a controlled substance. This is a level 10 non-person felony. Each of these 4 felonies entitle you to a preliminary hearing. At a preliminary hearing, the state of Kansas has the burden of producing evidence to make it appear that these crimes were committed and to show probable cause that you committed each of these crimes. A preliminary hearing is not a trial to determine if you're guilty or not guilty. It's a hearing to determine if there's enough evidence to require you to stand trial, or in other words, to be bound over for trial. At a preliminary hearing, you have the right to be present with your attorney, and you have the opportunity to challenge the state's evidence, to challenge the existence of probable cause for further detention or for further bail, should you make it. You would have the right to subpoena witnesses, cross-examine the state's witnesses, and present evidence on your own behalf. A preliminary hearing would apprise you about the nature of the crimes charged and the sort of evidence you'd be required to meet if you were to stand trial. If you waive or give up your right to a preliminary hearing, there will be no preliminary hearing, and you will be bound over to the district judge for further proceedings. You'll be required to appear at a later date before the district judge for arraignment, at which time you will enter your plea to the charges against you, including the misdemeanors. And until that time, you will be remanded to the custody of the sheriff unless you are able to be released on an appearance bond, and you would continue to be obligated to appear under the terms of that bond. Now, have you talked with your attorney about waiving your right to preliminary hearing?
Yes.
And do you need any more time to visit with your attorney before we proceed?
No.
Do you want to waive your right to a preliminary hearing?
Yes.
Are you voluntarily waiving this right?
Yes.
Has anyone made threats or promises to cause you to waive your preliminary hearing?
No.
Are you in good health today?
Yeah.
Are you taking any medications which might impair your judgment today?
No.
Mr. Favre, do you know of any reason why the court should not accept the defendant's waiver?
I do not, Your Honor.
Thank you. Ms. Gillette, does the state wish to waive its right to preliminary hearing?
The state does, Your Honor.
Very well, the court finds the state of Kansas has waived its right to a preliminary hearing. The court further finds the defendant has made a knowing waiver of his right to preliminary hearing after her right after consultation with counsel. It is therefore the order of the court that the defendant is bound over to the district judge for further proceedings. The defendant shall next appear before the court for arraignment. And Missy, what is available?
This case will go to Judge Ricky, and he is available July 10th at 4 o'clock.
July 10 at 4. Will that work, Mr. Favre?
That's perfect.
Very well. Miss Prim, you are ordered to reappear with your attorney by Zoom before Judge Ricky, July 10th at 4 p.m. Now, these charges allegedly occurred February 25th, 2025. I presume the defendant has been in custody since that time. Mr. Favre?
She has, Judge, and we would like to address that issue of her bond. She's coming up on the 4-month mark here. She's been in custody on this the whole time. She is under a $20,000 cash or surety bond with an ankle monitor requirement. And it's a very onerous bond. I'll just give the court the full picture that she does have a pending hold out of Morris County, and she has already accepted conviction for that offense. That offense was supposed to be presumptive probation. I spoke to her attorney over there, and it's kind of up in the air as to whether that would, I'm sorry. It was supposed to be agreed upon departure. I don't want to misspeak. But I've spoken to her attorney, and I'm not sure how that will shake out now, but he thinks he's still optimistic that it will still end up with her being on probation. We asked the court to consider modifying her bond to something lower she could possibly make, $5,000 cash or surety, keep the ankle monitor if the court is so inclined. She does have a history of FTA, so we understand why that would be something the court would want still. But the truth is that she needs to get a drug and alcohol evaluation for both our case and for Morris County. And it's just very difficult for her to do that process while she's sitting in jail. So that would be our request today.
Does the state wish to be heard, Miss Gillette?
Your Honor, she does have a history of failures to appear. She has had 3 on the case alone over at Morris County, and one of her convictions is failure to appear. She has a history of not coming to court, which is why her bond is what it is. It was lowered to $25,000 at her first hearing in March with GPS. It then was lowered to $20,000 with the EMD GPS in April. Then we had our next hearing today. And so each time we have gone down on the requirement for her bond. With her history of failures to appear, I would ask that the GPS remain on it. Again, we don't know how her case is going to shake down in Morris County. It is presumptive prison. There was to be a departure to supervision. I've looked at the plea agreement in that case, but then she's had failure to appear since then. So I would just ask that the GPS remain as a component of her bond and that it be a cash surety bond. So there's a bondsman knowing where she's at and trying to keep tabs on her as to whether or not she will come to court.
Mr. Favre, I cannot grant the motion with her history of failures to appear, with her multiple felony counts in more than one county, and with her presumption of imprisonment I think there's just too great a risk for her to not appear at her next hearing, although I note she is indicating she'd like to speak. Are you wanting to speak to your attorney,
To you,
Mr. Favre?
to
Uh,
you.
Judge, 1 second, Ms. Pram, I mean, 1 second, sorry. Judge, I don't have an objection to her speaking, but I would ask the court to consider, if the court's not open to a 5,000, maybe something, like 10,000. That's still a fairly hefty amount that a bondsman would go after her on. And if we keep the ankle monitor requirement, that's going to help her, have that extra incentive to not fail to appear. But she's just been in for such a long time, and it's just really hard for her to get a drug and alcohol eval, which the plea we're discussing will likely end up with her in a border box situation. And that, as the court's well aware, that treatment is a very important part to any border box consideration. So that's kind of the basis for what we're looking at. But I guess I'll let Ms. Prim speak for herself.
Ms. Prim, you want to be heard personally?
My thing is, I've only had one absconding. Once have I ever absconded, and that was on this case in Council Grove. I have completed every program, every probation I've ever done. I have never absconded, except that one time.
I think,
Um,
Ms.
and-
Prim,
huh?
I was going to say, your record on the Morris County case shows there's a couple of failures to appear. Now, I know there's some technical differences between absconding and
Right.
failure to appear, but I just think it's not a good argument to make that you're not a flight risk, because your record clearly shows you have been a flight risk at least a little bit on this Morris County case.
Once I ran away for 5 years. That was it. I have never had another bond, or another court date or anything. Now I failed to appear because I've been in here the whole time. That's the only reason why I fail to appear. I do when I say I'm going to do, usually.
Usually.
Yeah,
Mhm.
usually. But 5 years ago, I was doing drugs. I'm not going to deny it. But I
Well,
have been clean for 5 years.
on October 17th of 2019, I don't know if you were on drugs or not, but you have a charge of aggravated failure to appear now filed in Morris County. Now they do show, it looks like, that it was dismissed, but
Mhm.
it does show that you had that aggravated failure to appear. And you do have the charges that I mentioned in multiple counties. So at this time, I am not going to change the bond. Now, if you want to appear in front of Judge Rickey, he may change his mind and reduce the bond, or not change his mind, but change my position and reduce his bond to you. But I don't want to lower your bond and then have Judge Rickey wonder where you are should you decide you've got too much hanging over your head. It doesn't sound like you've had the presumption of prison over other cases that you have now. So I am going to deny the motion to reduce bond, but I will, if the parties seek it, order that an alcohol and drug evaluation be done in the county jail if someone locally is able to do that. And I know in Butler County that's easily accomplished because of the resources available. I do not recall if we have someone locally that can go into the Greenwood County Jail. Do either of the parties remember, either council recall if there's someone available?
I think we've used Lisa Gray before, but I'm not sure if she's available still.
Who is she with? Is she on her own, or does she?
I think it's a new journey or a new direction or something like that. I'd have to go back and look.
Right.
I think we've
Well,
used her.
Well, I will authorize that, and I will order that the evaluation be paid for as court costs so that they will have that assurance. Now, that's not telling them they'll be paid right away, but I certainly will authorize that because I recognize she's indigent from being in jail for so long. And if evaluator isn't willing to accept payment through court costs, then we can revisit that with Judge Ricky and see if we can use other funds. But at this time, those are my orders. Anything else, Ms. Gillette, from the state?
No, I can't think of anything else, Your Honor.
Mr. Favre, anything further from the defense?
Not at this time, Your Honor. Thank you.
All right, thank you. Ms. Prim is remanded to the custody of the sheriff. And Deputy Fisher, thank